Hi everyone. So today we will be dealing one of the cases Satyabrata Ghose versus Mugneeram, Bangur and Company Limited. This is a case from this 1954, and we'll be dealing in detail this case law. First of all, we will deal about the facts of the case. What are the facts of the case basically? So first of all, there was an agreement between the Mugneeram Bangur company and which was a real estate company actually, which was a real estate developer company, and the second party is the Satyabrata Ghosh. So first is Mugneeram Bangur Company Limited, which is a real estate developer company, and the second is Satyabrata Ghosh. Now what happens? Both the parties came into an agreement. When these parties came into an agreement with respect to the sale of a land, okay, for a sale of a land after the development. So when there was a development, after that, that particularly piece of land will be sale. Okay, so there was actually one big land, but that land has to be cut into the several pieces to make it a plot, and now the plot has to be given to the Satyavrata Ghosh. So there, after the development only, and now the third party, it's not a party to the contract, that was an intervention by the government of India. Now requisitioning the land basically during under the war time, so making it temporarily unavailable for the development. So government has requisitioned the land, and after requisitioning the land, it the land's development has been stopped, and when it has been stopped, you won't able to do some development upon the land. Okay, a real estate developer, that Mugneeram company, can't do any development in that particular land when it has already been requisitioned by the government. So I'll be telling you one term, that is requisitioning. Requisitioning means that the act of government or authority basically, when they are formally taking the possession of a property. So they are taking formally the possession of a property. When the government is taking formally the possession of a property, it means they have requisitioned the land, and now when they have requisitioned the possession of a land, so you won't able to do further development over the land. Okay, your particularly development will be stopped. So the third thing is this. So these are the some facts that I've already told you. Now breach. So what actually breached here? So Mugneeram company and requisitioning of a land, they said before the court of law that this has actually frustrated the contract, and now the frustration of contract, you might have understood that particularly principle, the frustration of a contract, doctrine of frustration basically, under the section 56 of the Indian Contract Act, which says that you haven't forecast any particular thing. Okay, you don't know what could happen in the future, but due to that unforeseen thing, your particularly contract has actually got suffered, and that suffer has culminated into a basically a thing that cannot be done, that is impossible to do. That means there is a frustration of a contract. Okay, that particularly contract cannot be done because of that unforeseen thing, and due to that there is a frustration of a contract. So I hope you got it. So there is some arguments that have brought before the court of law by the Mugneeram and Company Limited, Bangur Company Limited. So the claim by the Satyabrata Ghosh, what Satyabrata Ghosh is claiming before the court as a plaintiff, he's claiming, and he sued the company for the specific performance, demanding execution of sale deed or compensation. So Satyabrata Ghosh is saying whether the company do the specific performance, its contractual obligation, the company's contractual obligation is to perform its specific performance, to do the specific performance, or just provide the compensation with respect to that. Okay, or give that money back with the compensation. So this has claim brought by the Satyavrata Ghosh before the court of law. Now we'll be dealing with this in detail more, largely the issues before the court of law. So what are the issues that came before the court of law? The first is that, did the requisitioning of a land by government of India frustrated the contract under section 26, under section 56 of Indian Contract Act? क्या भाई जो वो रिक्विजिशनिंग ऑफ लैंड था जो सरकार ने करा, क्या उसकी वजह से जो कॉन्ट्रैक्ट है क्या वो फ्रस्ट्रेट हो जाएगा? दिस वाज द फर्स्ट थिंग दैट हैज ब्रॉट बिफोर द कोर्ट. द सेकंड थिंग दैट वाज ब्रॉट बिफोर द कोर्ट इन दिस केस वाज, कैन द कॉन्ट्रैक्ट बी स्पेसिफिकली परफॉर्म्ड डिस्पाइट द रिक्विजिशनिंग ऑफ लैंड? है ना, देयर वाज अ रिक्विजिशनिंग ऑफ लैंड. वी अंडरस्टूड very well, the government has intervened in this particular agreement and requisitioned the land from the company, and the company won't do any further development on that particular land. So had so the requisitioning of land, despite can the specific performance can be claimed, क्या उसको claim करा जा सकता है specific performance को अगर requisitioning of a land हुआ है? तो ये दो क्वेश्चन जो थे वो mostly has came before the court of law, and will be dealing the arguments by the parties that have brought that both sides have brought before the court. The plaintiff Satyabrata Ghose, first we have to listen the man what he's saying, and the government requisition was a temporary measure. So understand each and every term in a well way, so that you would able to make it connect. You would able to connect it in a better way. So the government requisition was a temporary measure, and it did not render the performance of a contract impossible. So the requisitioning of a land by the government of India was a temporary in nature. Okay, it was not actually for a long time, or the contract, the development of a particularly the land cannot be impossible, and it cannot be frustrated. That is means by the Satyabrata Ghosh. Now the second thing that he said, that the contract was still capable of being performed after the requisition lifted up. So requisition can be done during the wartime, and wartime the government can even take your land, okay, for can for any of the purposes. And after the war has over, the government will give back land to you, and the requisitioned land will be lifted up. And when it will be lifted up, so it means that that development can be possible easily. The development, the company can come again and can do development again. So the contract was still capable of being enforced. So this was the 2 point that was brought by the Satyavrata Ghosh as a plaintiff before the court. The second party is here Mugneeram and company Bangur Limited. What he says, what the company basically says, the requisition frustrated the contract because it made the development impossible, which was essential to the contract. So what was actually essential to the contract? The development impossible, and the contract was about the development of a particular land, that the development of a particular land will be cutted into the plots, and that plot will be given to Satyavrata Ghosh. Now the development has stopped because of the requisitioning of the land by the government of India. So the company is saying it is frustrated, so it cannot be possible, so the performance of contract was no longer feasible, we can say easily. That the claim by that said by the company. Now the judgment came, the Supreme Court of India led by Justice Mukherjee. So he ruled in the favor of Satyavrata Ghosh के फेवर में यहाँ पे जजमेंट आया, और यहाँ पे उनने 3 points he has kept, 3 points which were kept before the table. First was the doctrine of frustration. Under the section 56, okay, incorporate the English common law. Doctrine of frustration has came from the English common law. We need to understand the principle of frustration basically when it applies when an unforeseen event occurs, and the performance or the formation of a contract becomes impossible. Okay, it becomes impossible, you won't able to do that thing, okay, and it has become impossible, so the contract become frustrated. And the court noted that frustration does not applies to temporary impossibilities. So this is the point that we need to keep in mind, that there was a temporary impossibilities. That thing could be done after the development cannot be stopped after the upliftment of that requisitioning of land, requisition land, and that could be done again. Okay, सो कोर्ट इज सेइंग कि भाई जो गवर्नमेंट ने वहां पे उस समय उस लैंड को ले लिया था, पजेस कर लिया था कुछ समय के लिए, ठीक है, अपना पजेसरी राइट उस पर इन्फोर्स करके उसको आपसे ले लिया था राइट को कि आप उस पर कुछ नहीं कर पाएंगे, तो जैसे ही वॉर खत्म होगा उसके बाद यू कैन डू एवरीथिंग इन द लैंड. ओके, यू कैन, दिस इज नॉट अ थिंग जहां पे जो आपका कॉन्ट्रैक्ट है वो फ्रस्ट्रेट हो गया, नहीं हुआ है. Why it has not been frustrated? Because there are certain possibilities that you can do anything with respect to that land, okay, after upliftment of that requisitioning by the government. Second thing, first thing is there was a temporary impossibility. So these are called the temporary impossibilities. So there was no permanent impossibility. Second thing, temporary requisition. The court mentioned about the temporary requisition. So this kind of requisition was basically a temporary in nature. It was not a permanent in nature, because when the war will over, after that the company can do the development on that particular land, over that land, and can perform several activities. So that was actually a fundamental nature of a contract, है ना? So the temporary requisitioning cannot destroy the fundamental nature of a contract. The court mentioned about this. We need to understood the second thing. The first thing I told about the doctrine of frustrations was actually means that the terms were more explicit in this case, and second, the temporary requisition was told by the government, told by the court that how it will work. It was not a basically a permanent requisition. Third is the specific performance. The contract was enforceable. Contract was an enforceable. Now and the defendants were obligated to complete the development and the sale of land as agreed. So there was a specific performance on the behalf of that company, that Mugneeram Bangur Corporation Limited, whatever. So on the behalf of that company, that the specific performance, the contractual obligations lies, and the company has to do that particularly, has to perform their contractual obligations. The third, we have talked about these three important guiding principles that basically the judgment established on behalf of this case. Now we'll be moving some further, and we'll be talking the principles that the three principles that court established. The first is the frustration is limited. You cannot exaggerate the frustration, because you have to see that frustration is temporary in nature, or is it permanent in nature, or you cannot foresee it clearly, and then it becomes frustrated, है ना? Because you that thing becomes frustrated only when it cannot possible, it is impossible to do, then only it becomes frustrated. But here there was no impossibility, there was possibility to do that contract, okay, after the upliftment of that requisitioned land by the government. Second thing, so section 56 interpretation was more and largely enriched, and we can say that contract does not becomes impossible because of the increased difficulty or delays. So when there was a requisition by the particular government over the land, so it doesn't mean that the particularly that is impossible to do the development over that land, but it was delayed, some after somewhere it was delayed, and difficulty was there, inconvenience was there, but it doesn't mean that it is impossible to do. So section 56, that the doctrine of frustration which deals with, है ना, the interpretation was more and largely enriched by the government, or enriched by the court, sorry, है ना? So this is two things that we need to keep in mind, that how the principles were developed in this particularly case, Satyabrata Ghosh versus Mugneeram Bangur Corporation Limited, है ना? So the third is temporary impossibilities the court has discussed. That does not discharge a contract unless they permanently prevent performance. So you cannot discharge the particularly a contract, okay, over this particularly a temporary impossibility. It is a temporary impossibility, okay, it's not a permanent impossibility. Why? When it becomes a permanent impossibility, it is impossible to do that contract, and then the discharge of the contract can be took place. But here there will be no discharge of contract, because this kind of impossibility is temporary in nature. The court